Paragraphs 20 and 21 are attempting to salvage the claim by reframing it as inconsistent enforcement, deliberate indifference, constitutional right to safety. Legally, those are very difficult to sustain on the facts you've described. Let's separate rhetoric from law. Number 20, reports not handled consistently. 1. Different calls, different complainants. If some calls were made by store managers, some by third parties, some by Fredrickson, officers responded to different fact patterns, then outcomes can legitimately differ. Consistency does not mean identical results. It means similar facts treated similarly. If the underlying facts differed, differing outcomes are normal and lawful. Number 2, minimize the conduct. Courts do not measure investigations by whether officers adopted the complainant's characterization. They measure whether officers investigated, whether they applied statutory standards, whether probable cause existed. If officers concluded the conduct was civil or lawful, that is not minimization, it is legal classification. 3. Escalation argument. If escalation consisted of reciprocal live streams, public commentary, posting each other's videos, online insults, public filming that is mutual online hostility, escalation must be criminal to impose a duty. If both sides continued posting, commented on each other, amplified incidents that weakens any unilateral harassment claim. NADRA 4. Online publication, increasing risk. Speech about someone online is protected unless it constitutes a true threat, it incites imminent violence, it meets statutory harassment elements. Speculative third-party hostility is not enough. There must be specific, articulable threats. No. 21. Deliberate indifference. This is the constitutional pivot point. To prove deliberate indifference, he must show 1. A known substantial risk of serious harm, 2. Conscious disregard of that risk, 3. A constitutional duty to act. There is no general constitutional right to police protection from private actors. That is settled law. Constitutional right to safety. Outside of custody or state-created danger, there is no standalone constitutional right to police-provided safety. Unless officers affirmatively created danger, increased risk through their actions, encouraged misconduct. There is no PHA 1983 claim. Declining to arrest after investigation is not deliberate indifference. Provocation and mutual conduct. You raise a key issue. If Fredrickson live-streamed repeatedly about defendants, replayed their videos, used legal buzzwords, claimed crimes without basis, continued public commentary, did not disengage that significantly weakens, harassment claims, no contact narrative, fear-based damages, deliberate indifference theory. Courts look at totality of conduct. Mutual antagonism undercuts unilateral victim framing. What threats? That's the critical question. For constitutional liability, there must be true threats, credible imminent harm, specific violent statements. If there were no direct threats, no brandishing, and no unlawful conduct, then describing conduct as threats is conclusory. Courts dismiss conclusory allegations without factual support. Monell barrier. To impose liability on Larimer County or Fort Collins, he must show policy or custom, pattern beyond his case, deliberate indifference, causation. A single citizen dissatisfied with investigative outcomes does not establish a policy. If big picture assessment. If documentation shows repeated responses, investigations conducted, case numbers assigned, voicemails returned, no probable cause found, mutual online conduct, no true threats, no weapon brandishing. Then paragraphs 20 to 21 are legally fragile. They rely on narrative emphasis, not constitutional violation. If you want, I can now evaluate the overall likelihood that the law enforcement counts survive a motion to dismiss versus summary judgment, step by step.